questions from members. I'll recognize myself to begin with. I'm going to pose this question to each of you. I'll start with Mr. Williams. And IIJA contained provisions to streamline the permitting processes to help speed up project delivery, including codification of the one federal decision policy, especially as states and industry are continuing to face persistently high inflation, as has been indicated in our testimony today. It's important that we address needless delays in permitting to ensure projects can move forward expeditiously. So my question is this: the department has told the committee that it has fully implemented one federal decision and other streamlining provisions contained in IIJA. Mr. Williams, has DOT communicated that to you, or are you otherwise aware that these provisions have been implemented?
Thank you, Chair Crawford. We are aware of the US DOT's provisions with one federal decision. We've not yet had a chance to see that in action on any of our major projects yet. There's a variety of things that have factored into that, but we look forward to hopefully achieving that and seeing some benefits. Ultimately, in our view, realizing the benefits of one federal decision is going to be up to the willingness of each of the individual agencies that are involved to work with DOTs and other infrastructure operators to expedite their own processes internal to their programs so that we can ultimately see a reduction in the federal permitting time that goes to environmental decision-making in our country.
Thank you, Mr. Boyd. Any comments?
Obviously, Marc would have more insight into the permitting issues, but just from a contractor's perspective, obviously we'd love to see it streamlined. The faster the better, and as a contractor, we're sitting on go, and any delays is obviously we're not in favor of. So just from a contractor's perspective, we'd love to see it streamlined and sped up.
Okay. Mr. Dreher?
I share the same sentiment as Mr. Boyd. You know, a lot of times the permit process, when we bid a project, sometimes the permits are not obtained. So, you know, we're selected to start the project and, right, we don't have the permits. So sometimes that just leads to further delays. And on the front end of the job, right, getting all the permits before we start work and, you know, the clients put the job out to bid, just increasing that overall duration, right, is definitely poses challenges to the overall schedule.
Ms. Hammond, your comments?
Mr. Chairman, I think you're hearing a theme here. The one thing that keeps transportation investments moving is certainty of the funding, which you have applied in the IIJA bill, but also an understanding and quick processing of decisions at the federal level and permitting agencies. We know that any efforts towards moving the one federal decision forward to streamlining the processing time while protecting the environmental provisions of NEPA are important and will certainly save us funds.
On that note, how committed do you think the administration is to improving permitting processes, especially given the fact that President Biden has moved to reverse NEPA reforms made during the previous administration? I will go ahead and start with you, Mr. Williams.
Thank you again, Chairman. Well, we have seen statements that have come through the administration, through US DOT, that causes concerns about potentially overlaying additional regulations on top of what we see as statutory provisions in law. That raises concerns and questions for us going forward in terms of our ability to expedite the permitting, especially on the environmental side. One of the things that's very important for us in terms of streamlining that process, Texas and several states enjoy a delegation of NEPA authority to us, where we're responsible for administering the NEPA programs within the federal laws that exist. That has proven to be successful. We hope and expect that that will continue to exist. But that's an area that we have concerns that the administration is showing signs that they're pushing back on some of the flexibilities that are provided to states to take advantage of delegated NEPA authority.
Excellent. Anybody else have any comments on that? No? Let me ask you this, in the last almost 40 seconds that I have left. On greenhouse gas performance measures, the Texas DOT filed docket comments in opposition to the administration's proposed greenhouse gas performance measurement, or management rule rather. In that proposal, FHWA sets very aggressive targets for carbon emission reduction and effectively takes away from states the ability to set their own targets. However, there's no legal authority for this proposed rule. Such a mandate was actually specifically excluded from IIJA during negotiations. So putting aside the lack of legal authority, the proposed rule also does not distinguish between urban and rural areas. In rural states where largest cities are still relatively small, can't meaningfully reduce carbon by building a subway or a bus rapid transit system in an effort to reduce commuter automobile traffic, even if it was affordable. So is the administration's greenhouse gas performance measure a one-size-fits-all mandate? And how can states reduce carbon emissions from transportation in rural areas?
Thank you, Chair Crawford. We agree that it's our position in Texas that the administration's proposed greenhouse gas rules goes far beyond what is available in statute. We support continuing the reduction that we've seen in greenhouse gases, but the proposed rules, along with the targets that they've established, are completely unrealistic in terms of the ability of state DOTs through the transportation process to see those achieved.
Thank you. I will now recognize